You're welcome back. And now to judicial matters. The Supreme Court has fixed October 22nd for the hearing of a suit filed by at least 16 state governments challenging the constitutionality of the laws establishing the Economic and Financial Crimes Commission, EFCC, and two others. A 7-member panel of justices led by Justice Uwani Abba-Aji fixed the date after the states were joined as co-plaintiffs and leave granted for consolidation of the case in the suit originally filed by the Kogi state government through its Attorney General. The states that joined in the suit include Ondo, Edo, Oyo, Ogun, Nasarawa, Kebbi, Katsina, Sokoto, Jigawa, Enugu, Benue, Anambra, Plateau, Cross River, and Niger State. The 16 states said they are relying on the fact that the Constitution is the supreme law and any law that is inconsistent with it is a nullity. And now to discuss this, we're joined by Executive Director, Sterling Center for Law, Deji Ajare. Deji, it's good to have you join us. Good evening. Let's just get started because we're pressed for time. Do you think this move by the governors is politically motivated?
Absolutely. I think it is not only political motivated. I think it is just aimed at serving the selfish interests of the governors of those states who are seeking to challenge the constitutionality of the EFCC Establishment Act. Of course, you will agree with me that the state governments have been a major impediment to the implementation of various anti-graft laws across the country. And in fact, in recent times, Kogi State, which spearheaded this suit at the Supreme Court, has been in the news recently over the attempt to investigate the former state governor, who, of course, also installed the current governor. And without any doubt, this is the motivation for the current suit. And you will understand why the other 15 state governors also feel the need to join. It is basically self-preservation, self-interest. And I think that's what it is all about, nothing more.
And what specific sections of the Nigerian Constitution might the Supreme Court examine, to determine whether or not this is even legal in the first place,
Well, the Kogi state government has sought to rely on Section 12 of the Constitution, which, of course, requires that when international conventions are adopted, the two chambers of the National Assembly must approve of them, and then there must be some sort of approval from the state houses of assembly. This argument, I think, is very flawed because while the EFCC Act itself might have been something that was done in order to fulfill Nigeria's international obligations, and perhaps the Act itself might have adopted to a large extent a UN convention, it is not necessarily true and correct that the EFCC Act was adopting the convention. The EFCC Act, nowhere in the Act was it stated that this Act is, aimed at adopting this UN convention. Nowhere. And so where that argument is coming from can only be from a very ridiculous standpoint that only the Kogi state governor and other state governors can see. It is an act, a legislation of the National Assembly, and as such, it was validly passed by the National Assembly, applicable across the entire federation. There is no, or I expect the Supreme Court anyway to dismiss it swiftly and decisively.
I think at this point we need to establish whether or not there's been legal precedents, if any even exist, regarding challenges to the constitutionality of federal agencies, such as the anti-graft agency EFCC here in Nigeria.
Well, I don't even know about. I'm not aware of any suit that has sought to challenge the establishment of such agencies. But I can tell you that yes, there are laws that have been made in Nigeria at the federal level which seek or sought to adopt UN conventions. So, for instance, the Child Rights Act, the Violence Against Persons Prohibition Act, and other similar acts that were essentially intended to adopt certain international conventions. Now, these such laws generally will be applicable only at the federal level or to federal agencies only. And then, of course, they will only be made applicable by the states when they are adopted by the various states' houses of assembly. And well, these ones there were no arguments. Nobody sought to challenge anything. I think everybody just agreed that that was the position. But in this case, the EFCC Act did not state, there was nothing, whether in the recitals or in the main body of the Act itself, that says that it is intended to adopt a particular convention. So it is an act of the National Assembly made applicable across the country. Now, the argument being advanced by the Kogi state that the EFCC Act was derived from a United Nations convention and requires that approval by the state houses of assembly is misplaced. It is important to clarify that the establishment was done through a valid legislative process as provided by the Constitution, by the National Assembly, under its powers in the Constitution to make laws for peace, order, and good governance. It does not adopt a UN convention. It was merely created to fulfill Nigeria's international obligations. And of course, remember, to combat corruption and economic crimes. Remember, at that time, Nigeria was regarded as a pariah state across the world. It was just coming out from a very deeply resented military government. And there was a need, of course, by Nigeria, of course, to show that it was already ready to combat corruption. And this was what led to the establishment of the EFCC, the ICPC, and one or two other agencies like that. So it is a necessity for national security and economic prosperity. So the suggestion that every international obligation requires ratification by all states is not only impractical, but it's legally unsound, and I totally do not agree with it.
Well, Deji, I want to say thank you. We'll wait until October 22nd to watch what the hearing would be at the Supreme Court once again. But thank you so much for joining us. We appreciate you for doing this with us. Deji Ajare, he is Executive Director of Sterling Center for Law.